What is inducement of infringement? Inducement of infringement is a doctrine in patent law that holds a person or company liable when they actively encourage, aid, or cause another party to infringe a patent, even if they do not directly practice the invention themselves. In simple terms, if someone persuades or assists another to commit patent infringement, they can be held legally responsible for inducement. The origins of this doctrine are found in 35 U.S.C. Section 271b(1) of the U.S. Patent Act, which states, "Whoever actively induces infringement of a patent shall be liable as an infringer." Congress adopted this rule to prevent people from escaping liability by hiding behind others. Without it, a company could orchestrate infringement by customers or distributors while avoiding responsibility simply because it did not manufacture or sell the infringing product itself. The key elements of inducement of infringement are: direct infringement must occur. Someone must actually use, make, sell, or import the patented invention without permission. Without underlying direct infringement, inducement liability cannot exist. Active steps by the inducer. The accused inducer must take purposeful actions to encourage infringement, such as providing instructions, advertising infringing uses, or supplying components designed for infringement. Intent and knowledge. The inducer must know about the patent and intend for others to infringe it. Mere negligence or accidental assistance is not enough. A landmark Supreme Court case clarifying this doctrine is Global Tech Appliances, Inc. v. SEBSA Man, 2011. In that case, a company sold deep fryers that copied a patented design. The defendant claimed it did not know about the patent. The court held that inducement requires knowledge of the patent, but knowledge can be established through willful blindness, deliberately avoiding confirmation of a high probability that the product infringes. To illustrate, imagine a company sells a software tool that can be used in both lawful and infringing ways. If the company markets the tool specifically for infringing uses and provides detailed instructions showing how to infringe a patent, it could be liable for inducement even though its customers are the ones committing the direct infringement. On the other hand, if the tool is a general-purpose product with many legitimate uses, inducement may be harder to prove. Inducement also often arises in pharmaceutical patent litigation. For example, if a generic drug manufacturer seeks approval to sell a drug and its labeling instructs doctors to use it in a patented way, courts may find inducement. The reasoning is that the labeling itself encourages doctors and patients to practice the patented method. A curiosity about inducement of infringement is how it overlaps with contributory infringement, another form of indirect infringement. Contributory infringement applies when someone supplies a component specially made for use in a patented invention, knowing it will be used to infringe. Inducement, by contrast, is broader. It covers all forms of encouragement or persuasion, whether or not a special component is involved. The consequences of inducement can be severe. The inducer is treated as if they had directly infringed, meaning they may owe damages such as lost profits or reasonable royalties. In some cases, if inducement is found to be willful, enhanced damages may also be awarded. In conclusion, inducement of infringement is a crucial doctrine in patent law that prevents wrongdoers from orchestrating infringement behind the scenes. By requiring proof of direct infringement, active encouragement, and intent, the doctrine ensures that only deliberate misconduct is punished. Its application in cases involving technology, pharmaceuticals, and global supply chains shows how patent law adapts to complex business practices. Above, I leave you more videos so you can continue learning law. Remember to give us a like and subscribe.